Good morning, distinguished colleagues. It's high time to start our section. We are waiting for our key speakers, some of them already here, and I would ask those speakers who are in our auditorium to take their seats just next to me, and we'll be able to start our work. Our session is called Intellectual Property and Digital Rights as Tools for the Development of the Platform Economy. Today, due to the current conditions, due to the digital society, digital economy, the usage of the non-tangible rights and intellectual property is very relevant. As of today, such exclusive rights are used mostly in the digital service. We have new services and resources which are able to unite the users and the right holders of the intellectual property right. In other words, we're able to commercialize the intellectual property rights. And the code introducing the new norm about the digital rights is also related to this topic. It can be related to the usage of the intellectual property rights in the sphere of the digital rights. Today our speakers will explore that topic. They will speak about NFT tokens, digital rights, and the overall issue of commercialization and the usage of the exclusive rights. What is especially important in the area of our digital economy? I will give the floor to the first speaker, to Professor, and the name of that person stands for himself. He will speak about the rights. Ivan Anatolievich, the floor is yours. I would like to greet all the participants of our session, and I think that there are no forum where we do not have the forum which would skip that topics and will not pay attention to them. We have a lot of different publications. We even have a dedicated journal which are issued that is called Digital Technologies or Digital Law. And I'm, as the Dean of the Faculty of Law of the Moscow University, named after Griboyedov, is aware about that. And I know that not long ago, the presidential decree was taken to create the NGO related to the turnover of the intellectual property rights. And of course, it is not possible without the use of new digital technologies, without the use of new platforms enabling efficient and fast introduction of intellectual property into the economic turnover. This is one of the most important tasks for today. And I think that it is very good that the leading university dealing mostly with economics, but I see that they are very active in the legal field. The legal faculty is developing within the premises of this university. It is very good, and I see that the topics which we're discussing today, they are at the border of economics and law, and we are trying to create some publications. For example, in my paper, Intellectual Property, we publish a lot of very interesting articles, including those which contains polemics concerning the digital technology usage. And the key issue in the current times is the topics related to artificial intelligence. We have a lot of different speculations over the topic, and also there are a lot of, let's say so, revolutionary ideas, such as let's provide AE with the legal rights, and that will allow us to resolve all the rights. And probably you heard that in China, one of the judges decided that the intellectual property right could be attributed to the work which was created by AI. And I asked the question why the judge decided like that and how he explained such decision. And my students said that probably it was done just for fun, to see what would be the response of the society if the AI is recognized as the author of the created work. It could be done for fun, of course, but the overall question concerning the intellectual right is not a simple one, and we face different challenges. And probably you recently heard that one of the students using AI and neural network created his work for defense and did that only for 5 minutes. It was found out during his defense procedure, but it's a precedent. Just a few days ago, I was asked to comment the question related to the following. The voices are being stolen, and that is done with the voice of AI. They take the voice of the speaker or the newsreader, and then they use that voice for their own purposes. And currently, in the legal field, in the legal framework, we do not have any tools to somehow control such situation. And we do not have the clear understanding to whom we can attribute the right for the voice which was generated by the artificial intelligence. And we can consider it as some harm, moral harm. And one more problem which is currently at the market, and I think that will be the problem for the future as well, when AI creates new objects based on the already existing solutions related to, for example, educational process. And I'm sure that you understand very well that during pandemic, when we all switched to remote or distance training, when dedicated platforms were created, when lectures and courses were created, those courses were used in the training for students, and all you have to do is just to log in into a particular platform. In this case, we also see the same question, and what to do with the intellectual property rights to those objects. Who should be entitled to them? And for example, if a professor created that, is he the key person to be the right holder? And we understand that such situations related to objects which are created also with the usage of AI, they belong to the university, and most of them are created within the assignment and by a person who received salary in the university. But it is not always stipulated by the labor contracts. And what is more important, it often goes beyond the initial scope of the assignment, which was performed by a professor. And sometimes the product created by the professor is reused for different purposes. And today we can face the situation when digital technologies allow us to create a lot of platforms. On the one hand, people say that education should be affordable, and just the day before yesterday, there was a speech by my colleague and he said that we need to ensure that education is affordable and available. But when we speak about such availability, there still should be some limits. It should not be limitless. It doesn't mean that any dean, any professor, or any other employee created a product and then the university allows to use that product by the unlimited number of people through a particular platform. When it's about your students, when it's about your duties and responsibilities under the labor contract, that's one thing. But when you have the unrestricted access to the product, it's a totally different thing. And that's why when we have the public access for the courses, anyone can download them and even resell them. Recently, I had the case when a lady created a product. It was an interesting software for the development of small children, children with some mental issues. And she started to work under this plan, under this program, in the framework of kindergarten, then transformed it into the online courses and provided that service for the parents. And then she was really surprised to find out that some company sells her course at the price of 100 rubles. And that means that they get profit from her product without her consent, of course. And we see a similar situation when different digital platforms create the so-called tracks available for the general public. Colleagues, we also need to understand if we consent to something when we create the digital copies of our work, digital copies of our textbooks, monographies, your scientific work, which you might create within your assignments under the labor contract. But when such digital copies are uploaded to the internet, anyone can download it and use it without your permission. For example, I used to work in the academy and we published a lot of different and very interesting textbooks. For example, the textbook regarding law, regarding patent laws, and so on. And one of our professors, when he created a textbook, found out that the textbook was published in the internet without his consent. And we analyzed 25,000 of downloads were created. Naturally, neither academy, neither the author received a single ruble for that work. And this is an urgent problem today. And this is the problem which should be solved. Now we see that artificial intelligence is actively used when we create new software, when we create databases, but we also see the cases when the artificial intelligence is used in inventions, in creations of different models. And here we have three colleagues where two theses were defended for different scientific levels. And that was the first thesis where we had just a theory related to AI. Peter Moore had defended it, before our council. And I have a lot of different examples. We have music, portraits, which are created by AI. And one of my colleagues provided an article that is an article related to an interesting idea of creating of auxiliary or secondary invention. There is such a term when we have one element where we create the drug, and to protect such drug, we have a lot of auxiliary or secondary patents. And of course, the AI is created, and of course, we use the software to create such patents. The question is, if those secondary patents were generated by AI, who should be the title owner? My personal opinion is to have the following approach. Any object of intellectual property is an act of creativity. Currently, only a human being can be creative. AI can create an object, but the basis of such an object is created by a person. Because when we try to analyze the pictures by AI, for example, we understood that those pictures are created on the basis of many, many works of a particular artist. And then AI analyzes the style of that artist and copy it and create a new one. That is why I think that as of today, the key problem is to resolve the issue related to understanding who should be the owner of the intellectual property right. I believe this is the most urgent and pressing problems to which we have to find the solution in future, and we need to do it together with our policymakers. And I would like to reiterate once again that, and it's my deep personal belief, that we should not be tempted to believe that AI should become an author of some creative project. I'm referring back to the decision of that judge in China. I believe it's unacceptable, and I think that our legal specialists should work in that direction. Currently, we are discussing that at different platforms in universities, within the scientific society, and I believe that such discussions will contribute to the regulation of such an issue on the legal level. Thank you. I would like to thank Ivan Glisnets. We had a very good discussion issues which are of interest to the legal economy and to all the lawyers and economists who are facing such problems such as digital technologies. But we need to understand the technical aspects. We need to understand how AI systems work to make sure that we understand the overall issue, how we can protect the output of some work, for example. And I would like to give the floor to Igor Vladislavovich Pomkin, and he is the professor of the Department of Administrative Law and Procedure Chair of the Kutafin Moscow State Law University. His topic is the perspective of implementation of intellectualized analytics. Good afternoon, dear colleagues. If I may, I would like to bridge to have a bridge between the China case and my proposition. For example, I could understand the judgment of the China judge only if I view what happened. But I could say that sometimes the court decision is taken to prevent any speculations. We could have different procedures in the court, and from time to time we saw that some enterprise on the protection of animal rights or issuing or going to court, and I do not understand why we could have such criminal cases, because they are bold and sometimes stupid, and sometimes they see the animal on the picture, but the animal cannot be the right holder. And that's why sometimes the court had to decide to prevent such stupid cases. Then the second comment. A lot of specialists thought that that person just lied a little bit. Maybe AI did not write anything for that student. AI is able to perform rewriting, to deeply change the already produced text. Within that technology, which actually does not correlate with the AI, we won't be able to say so. And Mr. Fedotov, during our previous communication, he told the following. AI is mentioned, but when you communicate with the AI of Sberbank, you understand this is the artificial idiot, not intellect. And we would like to mention a few British studies, and they filled around 400 different startups, information of European countries who claimed that they either work with the artificial intelligence or are aimed at its development.
And out from 40 to 60% of them are not related to AI at all. And my PhD student, Mr. Market, and she is writing on the AI, and he attended the meeting in Skolkovo on AI, and everybody said this is nonsense, this is not related to AI, and we need to consider it at all. That's why let's be realists. But at the same time, AI is there. It's a relevant part of technologies. We have a fascinating things that we need to be looked at, but machine analytics. And the Supreme Court of China, in the document dated as of 2020, let me begin with it, and it is called on regulation and enhancement of AI in the judicial sphere, set a task to intensely introduce relevant AI technologies in the legal proceedings to ensure the legislative and judgmental capacity of the court, and they wanted to increase the pace of processing of legal cases, and the courts need to support AI applications to check evidences, to disseminate normative and regulatory acts and decisions, to assist in decision-making on all the claims and generation of legal documentation using AI, etc. This is a rather not gigantic but still quite extensive list that sets these tasks. Since China is already known during the pandemic by using AI extensively and sometimes to excessive degree, and to control people. But this is the fact. They invest a lot in AI. You need to consider it. That while we're speaking that AI is used in the court, in the court proceedings, this is just a small percentage related to whether AI can replace a human judge. It's just a very small percentage of the topics being discussed. To conclude, I can say many experts are against. By Ruden rector Oleg Yastrebov has pointed out the interesting aspect. There is a number of cases, a big number of cases, where both parties are interested in resolution and they don't care who is the winning party. And the most important thing, that the tail of all these burdens on the business of old obsolete contracts to be closed. And in this regard, both parties are ready to make use of this AI quasi-justice because they need to avoid the lengthy legal proceedings. They don't want to go to the arbitration court, and they want just to finish. And they are ready to use AI for such cases. From my perspective, we can be mindful of the AI, but my point is different. As I said, this is just a very small percentage of all the cases, and the major part is taken by machine legal analytics. This is what AI does. If we are talking about legal proceedings, secondary actions, like we need to select the citations in the case law, the citations from different cases, we need to prioritize them. So to find a relevant citation for the specific case, so machine legal analytics is there, can be used. But here we face the following. Once we say machine legal analytics, for many of us it sounds like a guinea pig, but something strange, because in our country we don't have any textbooks on the legal analytics overall. And only Isakov is the author from the High School of Economics, and Professor Baranov from Nizhny Novgorod Academy of Interior Affairs of Russia, and he is issuing recommendations on copyright and legal criticism. This is the legal analytics that we have. For your understanding, once we are, as lawyers, we are working on a decree or a law, we are coming with an opinion, or we either supportive or disputing, and it is not related to AI. This is related just to the analytics. Yes, we have a scientific-oriented consciousness. Yes, we use methods on the verge of science and applied analytics, but this is not increasing the knowledge. This is just a supportive function. Or if we give a legal opinion on some other lawyer's opinion, or we evaluate the legal standing of the opponent in the court, this is applied analytics. And it's very strange that we don't have any textbooks, and it will be really great if we have the first of a kind in the country, the first big forum on legal analytics. It will be organized by the Nizhny Novgorod Academy of Interior Affairs, and we are really thankful to the organizers. We will be discussing all these things, and if you are interested in this is what is related to the applied analytics. And in this regard, so we kind of got clarity on what legal analytic means and what is machine legal analytics stands for. Why do we need it? And some of the assessments and corporations across the world, they are processing such a volume of documentation. If we take a print and put a pile, we will reach the nearest constellation. Colossal data of massives of data, petabytes, and human brain is already exhausted its capacity to absorb it. And no AI to the full extent cannot replace a human brain, a human intelligence. And the translation by the AI is weird. And this is more like artificial intelligence rather than true capability. And we cannot, we don't have any basis to translate it into the human brain. It will never replace human brain, but it can help us to accelerate our capacity, like computing capacity in the predictive analytics. That is the most important element of the applied analytics. And once we become a part of the process, we begin to build, we begin to anticipate what our chances are in the process, what are the chances and ways to improve our chances to win, how to anticipate our opponents' standing and the stance taken by the judge. And we are making the digital twins models. This is not something that is done will be done tomorrow. This is done today in big corporations. They are using digital twins of the experts. We see the experts sitting in front of us. We make a digital twin of this person, and knowing this person's approach, we can propose templates, and she's just feeling it. She's just adjusting something in these templates, as in the Renaissance, the famous artists, they put just the last brushes on the painting. Everything was done by the apprentices. They just attached something really special to the almost finalized painting. This is what our real expert do. If our expert did 58 negative opinions and on the 59 gives a different position, the machine becomes curious. Why is that? And so it draws attention, and why it is deviating from its own standards. In the same way, in the digital manner, we model the judges' patterns. So machine picks, selects the citations of this judge from the previous cases. So it's not, it's like recklessly, but the AI begins to use its own words, and the judge can recognize in the opinion generated by the AI its own words. Now this is reality. So. And the number of judicial decisions, the court rulings in the case law that they need to be mentioned related to specific case, a number of clarifications of the Supreme Court plenum decisions on constitutional court decisions. And they are significant in terms of legal perspective, and so they can be used to justify legal standing. So machine can help you, and humans sometimes feel they are out of their capacity. It's exhausted, and we had several studies in the U.S. legal system. Up to 90% of judges confirmed that the lawyers forget to mention the most important cases. But machines, they don't forget. Speaking about machine legal analytics, sometimes it's not really advanced, sometimes it is advanced. And there are law firms that implement these technologies. And regarding the references or citations from the different legal cases that is relevant to the particular case, machines, they do it at a high level, high quality work. Machines are capable. Maybe not really at advanced stage, but usefully for the lawyers to do sampling of the legal norms and the law which is done and designed by machines and that operates with the law as a code. It takes a law as a code. Still, these machines, they are not at a breakthrough, not at the leap breakthrough stage. And there are publications on this regard. To be brief, the machine legal analytics, this is a search engine. It is searching, not in the clear logic, but in the fuzzy logic. They are searching, and from the masses of data, machine can fetch opinions by a specific lawyer, who is the best lawyer on these kind of legal cases in your country. So machine can tell you. So machine is fetching it from the loads, tons of information, and how this lawyer performed on a specific case. Statistics can be made on a specific lawyer, and so in U.S. law, so lawyers sometimes they're very aggressive. Is this lawyer aggressive, or this is a lawyer who tends to be silent? And machine can help you to make a portrait of such a lawyer, but machine will not replace humans within 100 years. But as far as the routine work is concerned, machine can be helpful. And we have lots of other areas. And the State Service magazine, I published my paper on this subject. And we're limited in time, so I don't want to deprive my other colleagues from their time. On this brighter note, I would like to conclude. So what I wanted to tell you, this is the most fascinating subject. What are the ways how to use applied machine analytics in the court proceedings? This is a toolkit, ontology as a toolkit, application of the technologies in the legal profession, in the legal activities. And despite lots of rubbish that we have in this area, still we have things that are really interesting, and they are well tested, and they really work. Thank you. Thank you for your very interesting speech. You are shedding light on the aspects that are not familiar for many lawyers, but are important for us, and we need to regulate it in law. And let us move on, and we have a series of presentations devoted to the legal protection of IP, results generated by IP, by AI systems. And Galina Grishenko, she is the Dean of Informational Law Chair and Digital Technology of Moscow Legal University, Kutafin University. She has PhD in the law, and she will tell us about the outcomes of the AI activities and legal issues and resolutions. Good day, everybody. To build on what my colleagues already started to be talking about, I would like to give you a more practical approach and results of what AI does. And we know that it operates in education, science, transport, public health. And since my job is related to legal aspects and dealing with AI, so I cannot resist mentioning this concept, the concept that has been developing approaches in the legislation with regards to AI. Yesterday, last night, I looked at the legal norms related to AI. I believed it's more, but this is what I found. And we know in our national strategy of AI development, there is a definition that is given to AI, but initially, this definition was not mentioned in the legislation. And for the first time in 2017, in the first edition of National Digital Economy Program, the definition of AI was given. And now we have a second version of this definition. Going back to the statistics, the documents related to AI, so they regulate AI. We have 21 regulatory acts in the legal framework. And if we take the general statistics where AI is mentioned in the regulatory documentation, we have around 700 documents where AI is mentioned. But sometimes it's just said that we will develop AI in the public health period. And what are the legal consequences of AI application? It does not say. And if we look in the legal documentation, we have only one federal law and only one presidential decree on AI. That's it. The rest are other resolutions by the government. We have just a few, the sectoral regulation And so it is related to the agencies that are related with AI. The next slide is showing it in a very compact manner. What are the sectors of our economy where AI is used? And many announce that we implemented this AI technology in our work. Once you take a deeper dive, and apart from the name of regulatory acts, I failed to find anything related to AI. It's just a name. And from these sectors, we can single out the key ones. And I'm really dealing with AI issues from the regulatory perspective. And the sectors where it is, maybe it's weak, but it's still present. This is public health, transportation, and also law. And in the legal proceedings, it is maybe not at the advanced stage, but it is engaged, it is actuated. The banking, of course, many banking organizations, they are switched to the digital platforms, the cryptocurrencies. This is a part of AI, of course. Going back to the definition for AI that is given in our strategy, it says about results, the outcomes. The outcomes are related to a context. The results that are obtained using AI capacity. What are the legal consequences for these outcomes? Is it for good or risks for the humanity? And I don't claim to be the ultimate truth, but I assess the risks, and there is a website that is accounting for the damage incurred by AI. And the cases that we also discuss with our students during workshops, and maybe not interesting, but unusual cases. For example, AI in the manufacturing side in a Western world country packed, used a small box. The box was placed on top of the employee, and she suffocated. And AI took hostages, and they called the police, and the robot negotiator was sent to negotiate. And so robotics in Russia, we use robotics as well for quite a long time, and the Ministry of Emergency Situations. But things go wrong. The robot came to the building, but he shoot all, he had a gun, the robot had a gun and killed all the policemen. And what is happening in Russia? And I found one single case recorded in 2019 in Kaluga region at the manufacturing site. What the robot did, grasped an employee and compressed him with two metal platform and kind of pressed the employee to death. And who is the guilty party, and what to do? Who is responsible for all these things? Because this iron hand killed the person. And thanks goodness, so we don't have it in the regulatory framework that the killing can be done by a robot, but in the labor norms, we wanted to introduce amendment and to specify a minimum percentage of robots, and you need to be protected. So robots can have such rights, and there is a certain distinguished percentage of jobs that can be given to robots. And so the head of organization, head of security, was held accountable for violation of HSC, and the relatives, they wanted to have indemnify the damage. So we already face problems. It's not just in Russia. This is of a global scale. And going back to the AI results, I divided it into two groups: positive outcomes. So you can give templates to robots, you can improve performance of the notaries, of the lawyers, and other legal workers. It can be given to the robots, why not? And we have statistics. And Fyodor Neronov, this is a prototype. Fyodor Neronov, it's a robot, 1 hour, 12,000 consultations. This is a robot lawyer. And we can give 2, maybe 4, no more. But we cannot give 12,000 consultations within 1 hour. And he is not paid, sorry. But we are getting paid. But this Fyodor Neronov, he does not need. And we have frauds in the banking sector and just dissemination of fakes, deep fakes technologies, damaging to the property, incurring damage to human health and life. What I tried to do is try to sort out the sectors where AI is already used. So developers, they claim it is used, it is implemented. And here I looked at the cases. What do we have? What is implemented already? And this slide shows the general overview, 7 groups altogether that we have. And it's not very detailed, of course, but some of them I would like to draw your attention to because I am personally engaged in it. And first, the unmanned transport. So in the million cities, we have like taxis. There are taxis, driverless taxis, and these statistics is more like negative because Uber in 2018 in the United States killed a woman on the unregulated intersection. And there are several cases like this, and they stopped it, and they are resuming it now. And so here comes a question. Whom to be held as responsible for the wrongdoing because incurring damage occurred. And so there is a danger for everybody. And the developers say that the driverless cars are much more safe rather than a car with a driver because humans cannot fail to correctly respond. And there are different perspectives like Uber taxi that killed a woman. Nobody got responsible. Nobody got called to the criminal responsibility. And the idea is we need to hold liable the car itself. And for example, there is a press to suffer, to make suffering for compression device to destroy, to apply sanctions to a car, to make a car suffer. And also there is a container with the asset where a car can be dipped and punished. And we don't have such ideas. From the logical perspective, it's still a question mark. And going back to responsibility, so either a developer of this driverless vehicle, and so you can design it to kill every woman wearing a red hat, so you can program it, or the owner of the company that is operating these vehicles. So the Western lawyers in Europe, they believe that we need to hold accountable owner of vehicle, owner of the driverless vehicle. And the driver's function is to ensure safe driving. If you fail to ensure safe driving, so you are the guilty party. And here again, the question mark. There are several automation levels from 1 to 6. And minimum automation level assumes that the driver is sitting inside behind the steering wheel and presses the pedals, and maybe you can drive a car remotely. So there are different ways. When there are nobody in the car, in the vehicle, this is the most questionable. This is a top level of automation. A driver is not inside.
So, in other words, there is a problem. And the next topic I wanted to comment upon, because it was already touched by my colleagues, because I believe that we would be interested in that, being the professors. It's the GPT chat, which is on the hype now, and this is the chat which allows the students to do something. There were several versions, and the version of the case with that student is that he spent not 5 minutes but 23 hours. Well, it's not so important. The result is that the work was in 82% authentic, and I think that it's pretty difficult, taking into account that anti-plagiat program allows you to catch a lot of different legal templates. And I decided to experiment myself. And for example, our kids already know how to get rid of the parent control on their phone. And I used the GPT chat. It used to be free. Now it's $20 per month. And I decided to experiment a little bit. I played a little bit, something like legal regulation of the cryptocurrency, development of the legal and tech technologies, and so on and so forth. And I cannot say that I was really impressed by the results produced by GPT. There were some very standardized answers. It compiled the text such as the technology will be developing. There are some legal framework in some countries. There are no legal framework in some other countries. So that was just general words. If my students answered me in such a way, they will have a 3 grade mark, because it's not the answer, it's just general words. And returning back to the student and to his work, it was an alarm for the professors. Please react somehow, respond somehow to the case. And we started to analyze that case. Should we permit people to use that? Should we not permit the people to use that? For example, in Australia, they prohibited to use the GPT chat. And if they found out that they used that, that will be derogated, and they even decided not to allow to use that at all. They have to write it down without any computer, just on paper. In Germany, they decided it differently. They decided that you may use the artificial intelligence tool, but you have to provide a link to that, a reference. And our Minister of Education of the Russian Federation was addressed with a request how the professors and teachers at schools should treat that technology. In my opinion, you should not prohibit it totally. You need to be adapted somehow. You need to be flexible. You need to make sure that the students could use that to some extent, but under a controlled way, in a controlled way. But once again, I also tried to classify the results of the activity of the AI, because the definition did not provide any explanation. I had 3 groups. The first group is for technical results, when the EA is performing some of the functions without the involvement of a human being. For example, drives a car, or, for example, sends the deliveries to the counterparties that are purely technical. Then there are also some AR activities which can have legal consequences. And the third class in my classification, that the creative, the intellectual one, when AR takes up the functions on creation of some intellectual property objects. And it was already mentioned that AR cannot create something from scratch. He should use some database, for example, some pictures by an artist, and then he compiles a new one. We had an experiment. We asked our students to find the picture which was created by a human being or by AI. And actually, that was something where you had to guess. You could not distinguish. It might work for some artists, such as Picasso or Dali, so non-classical ones. And I think that we need to discuss different ideas. Sometimes we think that electronic agents, animals, things could be a part of artificial intelligence. We won't be able to define it now today. I just wanted to highlight that this topic is relevant. And it's not only important for theoretical purposes. We need to understand who is the owner of the title, because the owner of the title is responsible for the consequences of its activity. And the first case we had in 2021 in the South Africa, when AI was considered as the author of the intellectual property. And also there were some other invents, for example, the self-heating food container or some lamp which would be used in case of a car crash, and that will send the SOS signal to make sure that somebody could help you after the car accident. So the legal cases were initiated in the courts of 15 countries. In Australia, first of all, they acknowledged that the AI is the owner of the right, but then in the next court level, they rejected that idea. And in January of the current year, a group of artists in the West were not happy that AR could become the owner of the intellectual property rights, and it's about the same NFT tokens, and it's about some other very trendy areas and NFT regulation. I would not dive deep into the details. The wording is very difficult. Before I read the information, I had an idea of what was meant. After I went deep into all that wording, I stopped understanding anything. All we know that we do need to respond somehow on the state level to such topics as NFTs and so on and so forth. And here we have two different opinions and approaches. Some believe that the legal area, the legal industry should move forward and we need to do something. And then there is another group which believes that we need to have a look what is happening and then respond to that. And we see now that both approaches are used. For example, the Ministry of Digital Technologies suggested to provide the services at the state service portal using the AI. And as far as I believe, it was this week when you have the new function when you can confirm your identity using the digital biometric passport. And the last moment I wanted to mention the last concept, which was also in trend, that is meta universe. We have the same question. For example, you may have a digital twin, for example, at the same state service portal. He may conclude deals, sell something, sometimes without our consent. Who would be responsible in that case? Who would be the owner of the right? Should it be us or should it be our digital twin? And of course, there is a question, what should we do with that? I tried to summarize that on my slide. And first of all, you need to understand what is artificial intelligence from the point of view of consequences, legal consequences. There is also the problem that our people do not trust AI. And that's why we need to make sure that our people are aware about the artificial intelligence capabilities. And I believe that we should also regulate such methods on a legal basis. As for the self-regulation, I think it should be inferior. And I think that our codes should provide for the necessary information and for the necessary controls to do that. What's also interesting to mention, to conclude with, although we have more questions than answers, I think it's great that we live in times when you can experiment with something, when you can try this in your work, at home. And please remember that you are a human being, first of all, and what was granted by nature should be used for the benefit. If you have any questions, I'm ready to answer. It was a very interesting speech indeed. We would be very happy to listen to you longer, but unfortunately our section is limited in time, and the organizers asked us to make sure that we finish in time. That's why I would like to ask the following speakers to just say a few words. And I would like to give the floor to Ruslan Budnik, Professor of Law of Digital Technologies and Biolaw Department of the High School of Economics, Doctor of Law Professor. Good afternoon, dear colleagues. I will try to be very brief, and I would like to support some concepts and ideas of the previous speakers. I noted that we are using the following paradigm. We believe that a human being is on top of the evolution. We measure everything with a human being. But this is not the only point of view available. For example, one of the most well-known scientists in the area of AI neural networks development, which are used greatly in the translations at the moment. For example, a lot of people laughed when something was translated from English into Chinese, and now people are surprised with the high quality of such translation. And that scientist believes that the competing neuron networks, the networks are pretty efficient, and those networks were developed with his participation either by himself or together with his students. And he believes that a human being is just an intermediary stage of the evolution, which is actually aimed at the creation of some new form of life, form of consciousness, which would be superior to a human being. And the situation which unfolds now is actually the process of such creation, probably. And we had already several references. I will start with some facts and then I will have the legal proposal. There were some references to the artists, and the artists did not like AI creations because they worked for the whole life. They created their own style. And the neural network can be taught to do that in a very short period of time, and it can produce such artworks very fast in a big amount of copies and so on and so forth. And it's not quite clear what to do with that. What is the way of usage of the previous works of the artist? Should it be free? Should it be somehow restricted? Should it request the consent of the artist? And there is such a concept that is called fair learning. And we may also use the term fair use term. Fair use, that's the free use for some particular purposes to some particular extent. And the artist society thinks that probably we need another new doctrine which allows us to understand how to deal with the possibility of the neural network to recreate some style of an artist. Probably it could be some database, the database which could contain particular elements or components which characterize the style of a particular artist, which could help to identify that style. And it's very interesting that, for example, when a rapper reads out the verses of Shakespeare, that's the first fact I wanted to mention. And the second fact, just in the middle of the previous year, I saw the following fact. One of the programmers who was working in the GPT chat development, for example, in the latest release, which is the most advanced one. And it is actually surprising. My colleagues were not surprised with the output, but a lot of people are surprised with its capabilities. There were scientists in that area. There were very interesting tasks in front of them. For example, briefly explain the relativity theory just in 2 words. And it could do that pretty well. And those who worked with that guy who was involved in the development of the GPT chat, and I would like to get back to the classification of the levels of development of the AI. First of all, we start with the artificial neuron. Then we have narrow, that is the level when the software is developed, when we have pretty high quality search, generation, and so on and so forth. And the next level is the general intelligence. That's the environment or the landscape which is equal to the mind of a human person, sometimes is even superior to the human intellect. And then the next level, which is even more superior. And currently, we are trying to identify the criteria when the neurointelligence is switching to the general intelligence. We understand that it's just a very short period of time, it's a snapshot. Right now, it is equal to the human intellect, and in the next second, it is superior. Getting back to criteria, there are two criteria which are most relevant. First of all, that is creativity. When you create something which didn't exist before, but such criterion is a very vague one. Sometimes you use such notions as insight when you do not have anything, and then you work on something and create something new. And there is also the second approach when quantity turns into quality. So that means that you have to have a lot of iterations, and nobody could understand when quantity turns into quality. It's a very vague limitation. We cannot understand when it happened. And thus, it's very difficult to understand when neural intelligence will become general intelligence for AI. When we speak about compilation, synthesis, using higher level of resources, and so on and so forth. I don't believe it's real AI. I think that actual AI starts only at the next point, at the next step of the consciousness. And we try to understand what consciousness itself is. Consciousness is actually that you are able to understand who you are, and it's recognition of yourself. And let's get back to the Google programmer, the guy who worked on the GPT chat. In his Twitter, he wrote that it's amazing. We see that AR has the signs of consciousness. Everybody told him that probably you spend too much time under the sun rays, just take a vacation. But then we saw that the GPT chat was deeply tested, and the latest iteration of the GPT chat demonstrates the results really surprising to specialists. Why I explain all that? I want to get to the message about the evolvement of the neural networks. And we also have another plane. It's startups, those people who invent something all the time, and it's not only about California, but also about Skolkovo. And we have a range of startups who are pretty irresponsibly work on different areas. And there are some startups who try to teach neural network to communicate in a way similar to a human being. So to teach a neural network to be you from the point of view of communication, just imagine if you are not in a physical contact with another person, then the way you communicate is you. And that was an experiment. The experiment was started by James Lahos, and he started the experiment from 2017. He publishes the results in the journal, and he also writes a book. And there are communicational characteristics of his father who died, and before he died, they started that experiment. He had cancer, he left, and the experiment is still going on.
And the most impressive effect for me, which is described by him, is a dead bot. Dead bot, and it's a chatbot. And the outcome is that the son and a close relative decides that this entity, under impact of the inputs, evolves. It evolves, and from his perspective, this is very close to what his dad would react to these same inputs, and how his dad would have evolved under the inputs. I apologize that we are limited on time, and I wanted to bring you to the point that it's not in the very far-fetched future that these patterns of communication, these models of myself, of you, and so this is a right for self-reproduction, and using a certain data sets. And we are data sets. This is something that we are impacted by, something that we watched, we saw, we read, that smartphone. This is your life logger. In fact, it accumulates data on your activity, and using these database, using these data sets, you can train a neural network to reproduce the models of your communication, to be you, if you will. And if this is happening upon your initiative without any violation of your rights, but sometimes it can happen with such a violation. And so we are at the point to frame the concept of exclusive human right of to be self-reproduced. And the toolkit to do it. I'm not talking about a neural network as operating system, but there is a co-authorship problem, so we don't have time to discuss it. But the like personalized information, the databases, data sets that makes you a person, so it needs to be recognized as a standalone copyright object. Thank you, Ruslan. I would like to give the floor to Dmitry Kirillov. And he is a specialist from our Plekhanov University and from the Research Institute on Innovative and Financial Technology Instruments, and he is a counselor of Lidens law firm. And he will be talking about relation between the copyright and rights for technology through NFT. I'll try to be brief because of the time concerns, and we'll go through real quick. And the phenomenon that we will talk now, it's a rather unique thing. This is the example that you can see across the board, where technology is running ahead of legal regulations, and as a legal profession, we need to respond to it, to this phenomenon, and we need to place it in our legal framework. NFTs, non-fungible tokens, such a thing that exists, first of all, abroad. And Galina mentioned the draft law. For me, it's rather strange. This is out of the context. We are waiting for the second edition. And definitions, terms and definitions. Let's make it clear. I don't want to go back to the academic things, to ABCs, but you need to have it to understand the problem. I made myself familiar with the publication, and they already published it on IP, and Nadezhda was involved. Thanks for reading it. Our chair is using a grant on digital rights, and this is important. And one of the conditions, I would like to discuss it later on, these grants, because I share your ideas. And where do we start with the art, objects of art from the Russian law, like science, literature, and art, results of intellectual activity and human intellectual activity, first of all. So an author is a human being, according to the civil code. And this slide shows some like these are aggregated these are, it's like simplified, like a cartoon picture, the pictures of monkeys, different NFTs are shown here. And this is a club of senior monkeys. And indeed, this is a collection of art, a collection of NFTs issued by one of the platforms. Going back to the subject of our section, FMC platform issued it. And permanently, there are 4 authors, and they sell it with substantial money. Each monkey is unique, and each monkey is a piece of art in the digital form. And going further, we will connect this picture with the NFT definition, and going back to our digital rights regulation. And our regulator takes its own path. We have the crowdfunding law 259 and issued in 2019. You remember there are 2 laws 259. It's a funny coincidence, and NFT and financial. What is interesting in the digital right per se, as our civil code understands it, this is a commitment or other right on the IP results, and one of such rights that might exist is a right to request the transfer of rights or transfer of rights to use these results of intellectual activity. Here comes the difference between the well-established perspective on NFT and our perspective. So it's not the piece of art itself, but the right to claiming the right to use it, NFT. One more illustration, and NFT picture, well known. This is another NFT token, which is offered by the Beeple artist and Christie's auction. The price tag was $69 million. This is a collage from 5,000 pictures. 5,000 days. It took 5,000 days to make this collage, and digitalized and sold it as a token with millions of dollars. So the regulatory definition for NFT, non-fungible token, is non-existent. It's a technological business description. And as a Western experience, we can cite you the decision of the London court taken last year. This was a dispute, property-related dispute with regards to loss of rights for NFT, and one of the respondents was Ozon Networks that owns NFT platform, which is very well known, and the judge, in a rather specific manner, tried to describe the dispute that was brought to his consideration, and he defined NFT as a flow of electrons that causes recording to be done on a crypto account. It's a strange definition, but it resonates with the definition of cryptocurrency. This is the aggregate of electronic data or digital code. This is a rather fuzzy definition that I'll give you, but this is some digital form of digital art. You play in words, and the judge said representing digital art of works, and that is a piece of digital art and also a representation of this digital art. So this is kind of intermediary. And in aggregate, the judge considered NFT as a property. This was the main argument that was replicated across the globe. So NFT is a property, and property-related rights material claim can be applied to NFT, and you can also impose a ban on alienation ban. And this is an interesting experience for us as lawyers. On qualification. Our reality, the right to claim your rights for the intellectual activity rights. So once we buy it from our investment platform, and this claiming rights, somebody says, I'm launching a collection of pictures, I will draw a picture for you, and just please buy my tokens, and using this money, I will buy sausage, it will make my living, and I will create for you. In exchanging for your tokens, I will give you the right to display my picture. Maybe I will make a software for you. And once you show this token to you, I will provide a license to you. And this is written in the digital rights agreement. And so we have a fork. What digital rights means for us? Is it a digital right as a property right, but of an individual kind, or is this is not a property-related law, just a license to use the object to be created in the future? This is another fork, and with regards to the IP object, what digital art object is, the pre-license agreement. We agree with our potential licensee that he will make a product, and in exchange of our token, he will give it to us. Or this is a license agreement with regards to the future art object, also a rather strange construct. But still, it can be materialized, and maybe the like order agreement to make an order. So we delegate a specific artist to make an object for us. So it's not an illegal practice yet, but these are the possible ways and pathways to move further. Speaking about NFT, we have the trial approach, the digital object, which is transformed into a token. This is an electronic code, and it also causes a fork, the token itself, that we store in a distributed ledger, and which is a property, as a judge of the Supreme Court of London told us. So, and is it like creation? We have a technical capacity, and what kind of NFT can be made. We can put a link to it on off-chain object which is kept in another network, or place the image inside the token, and then it becomes a digital piece of art. And or through this token, we conclude a licensing agreement to use this off-chain piece of art which is stored somewhere. So it requires a legal opinion, and our courts cannot qualify for it so far. NFT, is it a licensing agreement or not? Again, you will download this presentation later on and have a deeper look. And the rules of one of the most famous NFT services, the copyright, is ensured by a user who creates this token. And while a token is created, there is a specific field for metadata where, as a text, you can input the conditions to use this token, and you can also attach the license, which can be read by humans. And as an example for you, this screen, just a screenshot. For this specific conference, I issued NFT for myself. I entered the platform, and this is my bug. And I converted it into an NFT token. And it is issued, and it is stored in my wallet. And on the right, in the description field, the metadata is inserted, and where I can put a license based on which this token can be used as a piece of art, and everything which is embedded there. And here we can compete between the digital and text that can be read. And in Russian reality, the chapter 29 of the Civil Code allows us to use our commitments, to execute our commitments in automated form. This is like a prototype for the smart contracts. It makes a bridge to such a thing. And the last point to mention, 1 more minute, once we want to circulate NFTs in Russia, we might face a regulatory issue. The law on crowdfunding, on digital assets, they have restrictions. You cannot receive digital assets, digital currency as a counterclaim for your you cannot pay with these assets another way, to put it. And this limitation, this is a block. And so there is no criminal responsibility that goes along with it. But I can imagine the situation. The prosecutor service will try to deem a certain deal to be illegal and withdraw everything. Take all the money associated with this deal. And so we need to find out how embed, how to introduce this technology and match it with the legal realities. Dimitri, thank you very much. Very fascinating experience. It was very useful to get to know how practically to implement these norms. And to conclude this section, I would like to give a floor to Rima Shamilina, the Dean of Economic Activity Legal Regulation under the government of the Russian Federation and Economic Academy. And she will tell us how to apply AI in the fashion industry. Thank you for the floor. I'll try to be extremely brief, and this is more like applied area, and I want to protect AI. On the other hand, I want to show, or maybe tell you, what are the issues and challenges we have while we try to apply AI in design, in fashion industry, and what will follow for the designers and from the AI use perspective. The trends are changing rapidly. Almost every year, every day at the market, we get new designs. And so AI, design and fashion industry, they are so labor intense. It's a labor intense process. And AI tackles different tasks from the sewing to sorting of the dresses with high accuracy, with a high speed. So this is not a sewing lady that plans for a long time, is just adjusting, tailoring something to you. The machines, robots with the AI support, they can do sewing beautifully, and they can detect defects. And speaking about another side of this problem, the designers are considering to whether this process is labor intense, and so we have a service objects issue, and how to separate the work of a designer, the work of the fashion industry, and how do we use the AI capacity. And technology is a tool here, but back in 2020, Our Artemis Lebedev Studio launched a project called Artificial Design. I believe this was the name. And then they created express logos for the companies, express logos. And they really, really were satisfying for the customers. Maybe somebody got dissatisfied, but for a long time they kept it in secret that these logos are created by a machine. And now we are well aware that big companies they use technology to determine whether it's counterfeit product or not. The luxury brands like Burberry brand, it uses special platform to detect the counterfeit products, and the company is using big data, and they use loyalty programs, and the big data are derived from these loyalty programs, and they make guidelines for recommendations for the customers. And speaking about the counterfeit products identification, so they can tell for sure whether it's authentic or not in 99% of the case. And this AI allows the premium brands to stay competitive. The better this technology becomes, the more sophisticated it becomes, so the better for them. So the more products will be presented at the market, and technology, and they know, they do the count, and they clearly know what is the amount of products that needs to be produced for this special category of customers, so to do a better planning for their manufacturing capacity. So combination of human and artificial intelligence, this is for the better. We had different perspectives on the technology used here, but the only problem is on how to determine what the final result will be. And we need always to be mindful of the labor intensity of the work of a designer or artist in making a specific object, and how to decide who is the creator, whether it's AI or still a designer, human designer, or maybe just technology is just an auxiliary tool for the designer. This is who owns the rights, the copyright. This is the question. And there are other technologies like a virtual stylist, for example, very, very popular, and well-known companies, they implement it, and fashion industry students, they also use technologies. And we have a design library definition, and companies, they have collections, and they keep all these designs and styles, and so the technology is processing all these collections and all designs, and they analyze what kind of fabrics, what kind of silhouettes were used by the companies to, and then they're trying to fetch feedback from the customers to use something, not to use something going forward, maybe to use fabrics here. Fabrics are also important. And we have plenty of issues, but I believe that AI technology is helping. It helps to develop this fashion industry further, but some of the professions will disappear. But not in the nearest future, but still it can happen. Or a number of workers will shrink, but still, fashion industry, AI in fashion industry is a breakthrough for the designers, for the artists and stylists engaged in this sector. So thank you. Many colleagues had a question, and so I would like to share opinions on the sidelines. And we need to leave this room, but the forum goes on. We will keep working till the end of the day. All the speakers share their ideas on the margins of this forum. Thank you. This was a really, really interesting session.